Funding affidavit. Oh, actually, it's application by notice to a respondent, then funding affidavit. Please do take note that going forward, it requires you to be more practical. So if you are not a candidate attorney, and you don't get to draft as such, I suggest then you start learning how to do your drafts, because basically, what the guide is doing here is just they're explaining the different concept. But in order for you to actually grasp the gist of it, you would then have to go sit down and learn how to draft. They're basically just explaining the different types of applications, but the real work is in you learning how to draft. So remember the last video we had experta applications. These are applications where you are just bringing you as the person making the application, you are the only one that has an interest in the matter, and you only serve notice to the registrar and no one else. And then now we've got applications by notice to the respondents. So this one is brought by a notice of motion in a founding affidavit. It's not only addressed to the registrar, but to any other party against whom a relief is claimed, or anyone else whom you think it would be proper for them to get notice of the proceedings. So let's say you have you're making an application against someone, something of that sort. You can't just bring an ex parte application. You would then need to serve them notice. So now this is where you come in and serve notice on that person who is the respondent. And then we know that a notice of motion is headed by the name of the court to which the application is made. It sets out the names of the parties in the proceedings, like applicant and respondent. And then it also states that a notice is being done for such and such, and also states that an affidavit is filed in support of the application. So your notice of motion is basically either a 1 or 2-pager at max. Never, unless it's a long form, but really it is just a shorter version of saying, I want this. This is what I'm asking for. And with that being said, you are going to find my affidavit in support of this application, which is now my affidavit is more in detail. And then, so your notice of motion would also state then that your respondent has 10 days to oppose the matter. However, please be aware that if it is an application against a minister, you must give them 15 days. So that is about it for your application. Very straightforward. You must just make sure that you know that you've got 15 days for a minister and 10 days for a natural person or any other party, juristic personality. Then we've got a founding affidavit. So a founding affidavit is what we would annex to our notice of motion. Remember, we're telling them we are coming, this is what we want. And you've got 15 or 10 days to oppose. Now we come in, we annex our founding affidavit. Our founding affidavit will include various things, but the primary that you have to make sure that you have included is that you have set out the locus standi. By virtue of what are you bringing this application? Fine, you're approaching the Bloemfontein High Court. Does the Bloemfontein High Court have jurisdiction to even hear this matter? Are you domiciled within this area? What is it that makes you believe that you've got jurisdiction for this court to hear the matter? And then you set out the facts giving rise to the cause of action. Then here it would be you basically stating on or about this is what happened, this is what we agreed on. All those facts that now have propelled you to come to court, you are going to state there. You're going to also state your relief and justify why such a relief is sought. You are basically going to have to explain to the court, this is the relief that I want and why do I want it. So that's what you must make sure that whenever you draft your funding affidavit, you are able to tick these 4 elements. And then who issues and serves a note, an application. Applications are issued by the registrar and served by the sheriff. So that's about it. And then what happens now with unopposed? So we know unopposed is usually your expired application. So when it's unopposed, obviously no one is going to serve a notice of intention to oppose. So automatically you are also going to do a notice of set down, and your matter must be set down before noon of the preceding court date. It's always before noon of the preceding court date. And then obviously, because the matter is now set down, you would need to instruct counsel. And what should be in your instruction to counsel bundle? You have to include your copy of your application, your return of service, as well as a copy of the notice of set down. That's about it for your ex parte. And then what happens then if the matter is opposed? You served, and then the person said, I'm opposing because I also have grounds. So you would have served a copy of your application, then you get a notice of intention to oppose, and then you give the other party 15 days to file their answering affidavit. Once you've received their answering affidavit, then you file your replying affidavit within 10 days from receipt of the answering affidavit. So the general rule is that we are only permitted to file filing affidavit, answering affidavit, and replying affidavit, but the court may, on its own discretion, allow further affidavit. But the general rule is that the three, which is the founding, answering, and replying, it's enough according to the court. And then what happens if a dispute to the fact arises during an application proceedings? So we know with application proceedings, there is no dispute to the fact, hence we can decide it on paper. But what happens if a dispute arises? If a dispute arises, then the court may dismiss the application. They may direct that the evidence be heard and or refer the matter to trial. So these are the three things that if a dispute arises and we are unable to decide the matter on paper, the court is either going to dismiss, direct that oral evidence be heard, or refer the matter to trial. So that's it for your application. But the gist of this is actually for you to go sit down and learn how to draft your notice of motion, learn how to draft your founding affidavit. That's the most important part when it comes to this part. It just basically sums up the important elements that you need to consider, but the real work is actually in you sitting down, drafting a notice of motion, knowing how to cite your courts, how to cite your parties, how to word the heading of your pleading, and then also how to draft your founding affidavit in order that follows very well. So that's it for now. And then I will make another video. The next what's this? Part of the guide is basically enrollment, pagination, and indexing, as well as the hearing. There's nothing there, so I left that out and then went straight to what happens if a dispute arises. And then now what we're going to do next, it's this so-called plus con evens rule on the next session that I am going to post. But yeah, please go back and actually do your draft. Like in this part, the most important thing that you can know is drafting the actual thing. They may ask you some theory here and there, like what happens if it cannot be decided on paper? Then you know that the court may dismiss, direct oral evidence to be heard, or refer the matter to trial. Just do small bits and pieces questions, but the real marks will come from drafting. So you always want to make sure that you go into that exam and all your drafts are on lock. Otherwise, that's it from me, guys. More videos are following. Bye.